Okay. Hi, everyone. So, we are continuing ahead with contract only. And until the last class, we discussed lawful consideration. Today, we'll be talking about consent, how a consent can be said to be bad or can be said to be influenced by mistake, coercion, undue influence, misrepresentation, or fraud, and what makes the contract voidable contract and what makes the contract the void contract. So, we know the very basic that consensus ad idem. That means both the parties shall agree in the same sense and the same manner has to be there. If somebody is saying, I want to, sell my laptop, and the other person says, I want to sell my laptop for 1 crore, and the other person says, I want to purchase your laptop for 10,000. So, in that particular case, there's no meeting of mind. So there has to be some meeting of mind to enter into a contract. That means people shall agree in the same sense, same manner. If the consent has not been taken freely, or if the consent has not been given freely, it is forced by somebody through coercion, or maybe there is some sort of undue influence, or mistake is there, misrepresentation is there, fraud is there, then the contract is said to be not a good. I mean, the contract is based on not the free consent, but may be influenced by these five situations. So there the contract may become void or may become voidable. In case of mistake, the contract is always void. In the other four scenario, the contract becomes voidable. So, what is coercion? Coercion is committing or threatening to commit any act which is forbidden by IPC, or, for that matter, Bharatiya Nyaya Sanhita, or the unlawful use or use threat to use of physical force. So, whichever criminal law is, I mean, we have criminal laws. We have Bharatiya Nyaya Sanhita right now, but before July we had IPC. So, if something is being prohibited under IPC or Bharatiya Nyaya Sanhita, and somebody has used those things to coerce people to enter into a contract, then this coercion, I mean, contract is based on coercion, which is committing or threatening to commit, or unlawful use of force or use of physical force. So there the contract becomes voidable. Unlawful detaining or threatening to detain any property, or to the prejudice of any person whatsoever, something that other than physical force, but there's a kind of apprehension in the mind of person, there's a kind of threat in the mind of person, and because of which they are entering into a contract with the intention of causing any person to enter into an agreement. There it is said to be influenced by coercion. For example, A threatens to commit suicide if B, his father, does not give him his property. Is this coercion? Yes, because the person is threatening to commit suicide. A threatens B that he'll shoot A's wife W if B does not sell off his flat worth rupees 1 crore to him for 70 lakh. So there is a threat that, I'll kill your wife if you don't sell your property worth 1 crore for 70 lakhs. So there's a threat which is, getting in the mind of the person. A took a loan from B and left title deed of his house as a security. A repaid the loan. B asked A to sell off his house to him, otherwise he'll not release the mortgage. Is this course? Yes, because आप property paper release नहीं कर रहे हो. Yeah, whatever has been, kept as a mortgage, you're not releasing it because you want the person to sell the house to you only. So there's some sort of threat which is involved over here. So it is called as coercion. Then undue influence, as the word itself is there, there's some sort of influence on the party, but that influence is undue influence, which is a contract is said to be induced by undue influence where the relations existing between the parties are such that one of the parties is in a position to dominate the will of other and uses that position to obtain an unfair advantage over the other. Basically, where one person knows that he can dominate the will of another person. He knows that whatever he'll say, the other person will follow or has to follow. And therefore, that person creates some sort of undue influence in his or her mind. And because of that undue influence, the person enters into a contract. So there the contract becomes voidable. For example, be a spiritual guru convinces her disciple A that if A gives all his property to B, upon death, I'll go straight to heaven. So there's a convince kar rahe hain disciple ko, and disciple is so much into devotion and so much follows the spiritual guru that whatever spiritual guru is saying, they'll do so. So this is just a hypothetical example to explain you. Similarly, a lawyer knows that his client C has committed murder for which B has successfully defended C. L induces C to sell off his property worth rupees 1 crore to him for rupees 40 lakh because usko pata hai this person has committed murder. So trying to get benefit out of the situation. So there again is a undue influence. Then next one is misrepresentation and fraud. Misrepresentation is a misstatement of fact which is material to the contract. That means the person believes it to be true and that is why he is saying. He does not have a bad intention. Or maybe he believes it to be true, that is why he is saying. He does not want to deceive the other party. So there it will fall within the definition of misrepresentation. A misstatement of fact which is material to a contract. For example, A wanted to buy an old cricket bat he saw at B's shop as it had beautiful carving on front. B told him that Sunil Gavaskar used to play with the bat. B really believed that Sunil Gavaskar used to play. So B actually thought that Sunil Gavaskar used to play, and that is why this is what he is saying to the customer. Now, in future, if customer finds out that oh, Sunil Gavaskar never played with this bat, so this will fall within the definition of misrepresentation, and the customer can get the contract declared as voidable contract. Then we have fraud, a deliberate misstatement of fact which is material to a contract. That means आपको पता है something is wrong, but then also you are saying it in order to deceive. So what is the difference between misrepresentation and fraud? Misrepresentation, there's a misstatement of fact. In case of fraud, there's a deliberate. That means जानबूझकर आप बोल रहे हो. You know something to be false, but then also you are saying. So this is what is a fraud. A saw an old cricket bat at B's shop with beautiful carving on front. B told him that Sunil Gavaskar used to play with this bat. The very next line says, B never really believed. That means B ko pata hai Sunil Gavaskar never played with this bat, but he is hoping that A will buy that bat. A will buy and purchase that bat. So there is a sensing and amazing opportunity to obtain Gavaskar's bat. A purchased it. So basically, you know that this person may purchase, is a big fan of Sunil Gavaskar. मुझे पता है नहीं खेलते, he had never played with this, but then also I'm saying because I'm sensing an opportunity कि ये bat मेरा sell हो जाएगा. So there's a kind of fraud. In case of fraud, mere silence does not amount to fraud. That means unless and until you inquire from the shopkeeper, unless and until the shopkeeper has, after you inquired, then he tried to remain silent, so there it will amount to fraud. But where you have not inquired, he's not bound to tell you all the details, because mere silence does not amount to fraud, and there are certain duties on us also. Buyer be aware, caveat emptor. So keeping that in mind, if you haven't asked, then you can't hold the person liable. Then mistake, we have seen that when both parties to an agreement are under mistake as to matter of fact which is essential to agreement. Mistake of law is not an excuse, otherwise, everybody will start saying that I did not know the law. So, keeping that in mind, it is applicable to everybody that mistake of law can never be taken as a excuse. Mistake of fact is allowed. Mistake of fact can be with respect to identity, can be with respect to subject matter, it can be with respect to identity and nature of the subject matter. For example, A tells B that A tells to B that he is P and wants to sell his car to him. B agrees. A approaches B believing him to be S. So he thought B is S and offers to buy his property. B agrees believing A wants to buy his property. So both the parties are under mistake that who is who. So there is a mistake with respect to identity. Similarly, mistake as to substance of subject matter. A wanted to sell his plot of land to B. A contract was entered into. However, at the time that plot of land was acquired by government, but neither party knew this fact. So the subject matter is no more there. I mean, it is with the government, so you cannot enter into the contract. So mistake as to substance of subject matter. Then mistake as to identity and nature of the subject matter. A and B enter into a whereby A sold his standing crop to B. It was later discovered that the crop was destroyed by burning at the time. That means subject matter is no more in existence, so there cannot be a contract. A wanted to sell his car to B for which they had entered into a contract. It was later discovered that the car is actually owned by C. So there is a mistake as to identity and nature. Identity means you believe somebody is to be someone else, but You are actually not aware about the identity. Similarly, subject matter with for which you want to have a contract, there's some mistake or maybe some confusion with respect to that particular subject matter. Then we have Section 11 of Indian Contract Act, which says all parties are competent to contract. Basically, Section 11 says that a measure can enter into a contract, a person of sound mind can enter into a contract, or a person who has not been forbidden by law can enter into a contract. So, when you interpret the section, what you get to know is that a minor, a person of unsound mind, and a person who has been forbidden by law, they cannot enter into a contract. So, minor is anybody who is below the age of 18 years, they cannot enter into a contract. Any contract with a minor who is below 18 years of age is void ab initio. So if there is a contract between void ab initio means something which is void or not valid since the beginning, since the inception. So let's say if there's a boy called A, he's 15 years of age. He purchased something from a shop and he said, my father will come and give you the money. And now his father is refusing to give the shopkeeper the money. If the shopkeeper wants to file a suit, he will not succeed. Why? Because the contract is with a minor. And a contract with a minor is void ab initio. Even if minor has said that he is above 18 years of age, in that case also, there cannot be a contract. And it is void ab initio. Even if the shopkeeper was under this perception that he is a major, again, there cannot be a contract. But if we take into consideration the according to general rule, a minor cannot enter into a contract. But there are certain exception. There's just one exception, which is talking about necessity. If a minor has been supplied with necessary of his life, which may be clothes, fooding, education, and all, so in that case, it can be enforced when minor comes of age. That means when he turns into a majority, it can come to an enforce. For example, if there's a contract between a miner and a shopkeeper, where shopkeeper is providing him with books, bags, pencils, notebook. In future, when the miner turns into a major, the shopkeeper can get it enforced. But let's say where a miner went to a shop and purchased a luxurious jacket, and he said that my father will make the payment. Now, father did not make the payment, and the shopkeeper is taking the defense that this is a this is a jacket which is very much necessary for the miner because it's a winter season. So maybe this is something which is necessary, so considering that, the contract is enforceable. But when we take into consideration the necessity, a luxurious jacket or a luxurious watch, or for that matter, something which is of luxury, it can never fall within the definition of necessity. So here again, the contract is with a minor, and because it does not fall within the definition of necessity, this contract cannot be enforced. So necessity means something which is very much needed for the survival, for the existence, or without which your life is incomplete. You cannot run away your life. Your life, not run away. Run your life. So there it plays a very important role. Then second is person of unsound mind. So anybody who is not able to figure out what is right, what is wrong, they may be called as a person who is of unsound mind. So a person of unsound mind is not entitled to enter into a contract. And if they enter into a contract, that contract is void ab initio again. But then there is again an exception to the general rule of unsoundness of mind also. So let's understand this through example. Suppose A is generally of unsound mind. He does not understand what is right, what is good, or what he or she is doing. Now, he entered into a contract with B. But when he entered into the contract with B, उसको पता था what he is doing. Actually, he understood the nature of the contract. He understood that he is entering into a contractual obligation, let's say for certain sale and purchase. So, in that case, even though generally he is of unsound mind, but at the time of entering the contract, he understood the nature of the act. So, in that particular case, it will be called as a valid contract. It will not be called as a void ab initio. Similarly, generally, a person is of sound mind. Let's say the person is very good, understands each and everything. But when he signed the contract, he wasn't able to figure out what he did, or he did not understand the nature of the contract. So in that particular case, even though generally he is of sound mind, but because when he entered or signed the contract, he was not able to figure out what he or she is doing. So in that case, this will fall within the definition of unsoundness, and the contract will become void ab initio. Unsoundness of mind is a defense under civil law, also under the criminal law, also under IPC, under Bharatiya Nyaya Sahita. Also, unsoundness of mind or lunatic person or a person who has been involuntarily intoxicated, all these are defense under, criminal law. Similarly, the same thing is a defense under civil law, also under contract law also. And the last one is person who has been forbidden by law. Maybe let's say a person has been declared as a insolvent, maybe, let's say, or maybe a person who has been declared as a bankrupt. So if you enter into a contract, the person may not be able to pay you through any means. So where the court has put up a restrictions on a person that you cannot enter into a contract. So if a contract is being entered with that particular person, the contract becomes void ab initio. You must have seen or must have heard also, the very general basic example I'm giving is not with the respect to contract, but to understand you, to make you understand that suppose there's a person who is being released on bail. So court does put up a restriction on that person that you cannot leave the country, or you cannot travel, outside India, or you may not go to any particular place or leave the city without informing us. So their court is putting up a restrictions on them, forbidden. They are being forbidden from traveling. Similarly, there are person who are being forbidden by court from entering into a contract. So if there is any contract with a person who has been forbidden by law, then that contract becomes a void ab initio contract. So this is all about today's session, guys. See you guys in the next class. Thank you.